Exactly 5 o'clock on my watch. Let's get going. Good evening, everybody, and welcome to the Trafalgar webinar series on unlocking the secrets in HOAs. My name is Peter Menon. I'm the Director for Legal at Trafalgar Property Management. Joining me today is the stellar Corinne Kutsia, Trafalgar Property Management National Community Schemes Manager, as well as the lovely Zerlinda van der Merwe, as we said in our newsletter. She needs no introduction, but just a quick snapshot on her career to date. Zerlinda graduated from the University of Stellenbosch with her BA, LB, and LM degrees, both cum laude, while completing her LLM thesis, specifically focused on the constitutionality of sectional title rules. After graduating, Zerlinda joined Pam Golding Property Management Services as a managing agent. Following this practical experience, Zerlinda completed her articles with Marina Constance at BBM Attorneys, and followed by appointment as a specialist community schemes consultant with Professor Graham Paddock at Paddocks. Zerlinda then went back to her roots as general manager at Pam Golding before she co-founded TVDM Consultants. Thank you very much for joining us, Zerlinda and Corinne. On our agenda this evening, we are going to obviously be delving into the secrets behind HOAs. Zerlinda is going to take us through the terminology, other associations, amendments, membership, CSOS, dispute resolution, highlighted clauses, as well as any supporting documentation. Thereafter, we will be doing a live Q&A with Zerlinda, myself, and Corinne. Just a couple of housekeeping rules before we get started. The slides and a link to the YouTube channel and this video will be posted tomorrow morning by Corinne. Expect an email in your inbox. Kindly ask all questions in the Q&A. So if you have a look at the bottom of your screen, there is participants, the chat, a raise hand function, and then Q&A on the right-hand side. Please don't paste your questions in the chat, paste it in the Q&A. Much easier for us just to gauge and answer your questions throughout the session. Any questions we might have missed, we're going to leave until the end for the verbal Q&A session. And if you still have an issue that has remained unanswered, we're going to give all our contact details at the end as well. Please feel free to pop us an email, contact us. Zerlinda is always incredibly helpful, and the team at TVDM, and we thank them for that as well. We are going to be finishing promptly by 6 p.m. Also, Corinne is going to put up a link now in the chat, as well as in the end, for her introduction to HOA's course, which you can go do free of charge. We'll also be sending through a short survey at the end. Please go and complete that for us. Very important for feedback, comments, as well as other topics that you might want to discuss on these webinar sessions. We do have a few scheduled webinars upcoming on the 24th of April. It is going to be Who Pays with Jennifer Paddocks. Sure, we are all looking forward to that one as well. And then the 22nd of May, there's going to be an internal webinar with our National Accounting Manager on top financial tips for trustees and directors. That actually ties in very well with our newsletter this month, which is all about finances, obviously focused a lot on community scheme finances. And we thought it's a very hot topic with the upcoming budget speech, as well as the proposed budget, or the secondary proposed budget as well. If you have yet to subscribe to our newsletter, please go and do so. We'll send through a link in the chat as well that you can go and subscribe, as well as to our social media platforms. Corinne has actually recently launched a WhatsApp channel. So just go and search Trafalgar Property Management directly on your WhatsApp, and you will be able to access that and Corinne's top tips every single week. Before I speak too much, let's get going. Zerlinda, thank you once again for joining us. We're very excited to have you, and looking forward to unlocking some secrets during this webinar session today. Thank you.
Awesome. Thank you so much, Peter and Corinne, and Andrew in his absence. It's always great to chat to you guys. And when you approached and we spoke about the topic of homeowners associations, I thought it was quite fitting, because this year TVDM consultants are really trying to put out more information relating to homeowners associations. And for those of you online and are not yet a member, we have also started a Facebook group, Homeowners Association Living in South Africa. So it's a great platform if you have any questions that you'd like to be answered, and it's growing every day, which is great. But one of the problems that I find in dealing with webinars and seminars and events and answering questions on a platform like that is that when it comes to homeowners associations, there really is no generic answer. So I think the topic of unlocking the secrets behind homeowners associations is almost like unlocking the tips and tricks to better understand homeowners associations and to better understand where you can go and look to get information for homeowners associations. So I think let's kick off with the next slide, Corinne, and we'll chat about terminology. So I find very often when I answer questions, both on platforms or during webinars or events and during my consultations, that the terminology that one uses specifically related to homeowners associations is so important. I received a request today actually to send a quote for a set of complex rules. So a complex could be either a body corporate or it could be a homeowners association. And they spoke about the conduct rules, but at the same time, they spoke about the conduct rules of the homeowners association. So normally when you're dealing with a homeowners association, you don't speak about conduct rules, you speak about estate rules, or in a non-profit company, you speak about the board rules. So it's very important to use the correct terminology. So just some of the biggest terms that we find with homeowners associations is firstly the type of homeowners association. So we have two different types of homeowners associations, which can also be called owners associations, property owners associations, master homeowners associations, and it could be called residential homeowners association or residential association or residential estate, all sorts of weird and wonderful things. There isn't any statutory requirement for a particular form of naming. So the two types is your common law homeowners association. Interestingly, it's actually deemed to be established as a body corporate, but not a body corporate in the sectional title context, but rather a common law statutory body of persons, not to be confused with an association of persons. That's not a homeowners association, but we'll chat about that a little bit later on. So the common law associations or homeowners associations are also dependent on the jurisdiction that you're in. So in the Western Cape, Eastern Cape, and KZN, we've got common law associations, whereas in Gauteng and many other provinces, you only have non-profit companies, the old Section 21 Companies Act homeowners associations. And a very quick way to see whether or not you're dealing with a common law homeowners association or a non-profit company is that in terms of the Companies Act, the name of the homeowners association, if it is a non-profit company, actually has to have the letters NPC registered behind the name. And it will also have a registration number, which is a company registration number, which a common law homeowners association will not have. So we know in bodies corporates, you've got an SS number. In homeowners associations that are non-profit companies, you'll have a company registration number. For a common law homeowners association, there won't be any number. So those are the two main types of homeowners associations, but I'll talk about a third, less often found association, I think in a couple of slides' time. And the non-profit company has a memorandum of incorporation. Previously, it was called the Articles of Association under the Companies Act of 1976. Under the 2008 Act, it was needing to be converted in a set period of time to a memorandum of incorporation. And a memorandum of incorporation does have to have a few set or prescribed clauses. These are called non-alterable provisions. So it's things that cannot be changed. In terms of the Companies Act, it is what it is. It doesn't matter if 100% of the owners agree. It's not something that can be changed. And if a memorandum of incorporation is amended, it needs to be filed with the CIPC, and the CIPC will actually check to ensure that non-alterable provisions haven't been changed. The things that are alterable provisions, luckily, are the things that we look at in a residential homeowners association. And they can range from who can be directors, how long they can stand as directors, notice periods, quorum requirements, and all those fun things, whether or not a meeting is allowed to be hybrid or remote or physical, what jurisdiction it needs to be in. So there are quite a few usable, alterable provisions. I can actually share with you afterwards a list of alterable versus non-alterable provisions that you can add as a link to the webinar. I think it'll be quite useful. And then memorandums of incorporation have to be signed by the founding members of the association. So it would be either the developer, alternatively the directors at any point in time of amendment. And it has quite a few statutory schedules that need to be attached to it as well. So when you read a memorandum of incorporation, it's quite a complicated document to read and to understand, but that's simply because of the statutory requirements under the Companies Act. If you are still finding articles of association, those articles of association cannot be in contravention of the prescribed memorandum of incorporation, and it cannot be in contravention of the Companies Act. There was a period of time that all homeowners associations were allowed to convert to from articles of association to memorandum of incorporation without there being any penalties. It was a number of years, and we very rarely find a homeowners association that has not converted and has drafted a new memorandum of incorporation. A common law association, common law HOA, has got a much simpler constitution, and under the land use planning ordinance of the various jurisdictions, it simply said that in terms of the constitution, the members, in other words, the owners of, they call it units, with land units rather, within the homeowners association have to be a member of the association, nothing else. So the contents of the constitution was very much up in the air, and it solely depended on what the developer wanted to put in place and later what the members wanted to put in place. There are certain municipal jurisdictions, it's the Department of Planning and Building Development Management, that has a legal department that is quite thorough in its review and approval of constitutions, amended constitutions. In my practice, I've only dealt with 2 local authorities that have been quite stringent. Now, after the time of Lupo, we do have a checklist that needs to be completed, a checklist that is submitted by the local authority, and we have to make sure that any amendments to the Constitution contain these items that the checklist has set out. And then depending on the type of development, there might be additional requirements of the local authority. We often also find that in constitutions, it has a clause that says that no amendments may be made without the prior written approval of the local authority. In our experience, the local authority first want the members to approve an amendment before they will actually consider it and review it and approve it. But again, most municipalities don't review it or approve it. They simply rubber stamp it and keep it on record. For a memorandum of incorporation amendment, you have to be very clear with your special resolution as to when the amendments come into place, whereas with a constitution, the amendments come into place upon the passing of the special resolution. So those are another 2 terms, constitution and memorandum of incorporation. And then the other supporting documents, and you'll find some homeowners associations will have a constitution and a set of rules. Others will have a constitution or an MOI, 2 sets of rules, architectural design guidelines, landscaping guidelines, fining penalties, access control procedure, short-term letting procedure, you name it. The most important piece of information that I can give is if the supporting document is not mentioned in the constitution or the memorandum of incorporation, it's as though it doesn't exist. And most often the supporting documents are only subject to amendment by the trustees or the directors. So most often it's not a document that has to get approved by the members, like a special resolution or unanimous resolution in a body corporate for conduct and management rules. But again, the constitutional memorandum of incorporation will actually set out the level of approval for various documents and what these documents are. Sometimes the constitutional memorandum speaks about regulations or policies, guidelines, procedures. So pretty much whatever the wording is, those are the documents that the board or the members or even a committee can put into place. So it's very important to look at the main document, which is the constitutional memorandum, to see whether or not the supporting documentation actually bears any weight. Another important point to mention is that when there is an amendment to any of these supporting documents, these amendments have to come to the attention of the members, and sometimes the constitutional memorandum of incorporation can actually provide that until such time as it's published or it's drawn to the attention of the members in whatever forum, it is actually not applicable. So very important to look at that. So that's another couple of different words. Estate or conduct rules. I normally find that they're called estate rules, not conduct rules. And of course, in a homeowners association context, we mustn't get confused between conduct rules for a body corporate and conduct rules for the homeowners association. Then from a management perspective, the biggest difference is that in a body corporate, we speak about trustees. In a common law homeowners association, we speak about trustees as well. Whereas in a non-profit company homeowners association, we speak about a board of directors. However, in a constitution, you could change the wording of trustees to be trustee committee, or you could be committee, or you could speak about executive committee or the executive. It really does depend on the constitution. And then you would have subcommittees very often. I find it more in non-profit companies. And then those have to be mandated. And then we'd have like an estate manager as opposed to a building manager or a complex manager or a caretaker. But I do see that bodies corporates also call their managers estate managers sometimes. So yeah, very, very confusing. So it is quite mystical and mysterious, and one has to be very careful about using the correct terminology. So that's just some of them. Karine, we can move on to the next slide. Thank you. All right, so the other associations, we did mention the Property Owners Association, the Owners Association, the Master Homeowners Association, all those fun things. We generally find that sub-associations or Master Homeowners Associations come into the context where there is a larger umbrella association. So if you're in Cape Town, you'll know about Century City. Century City is the Property Owners Association or the Master Homeowners Association. And below it, there are various other entities, bodies, corporates, and homeowners associations. Steyn City in Johannesburg is another lovely example of just how complicated this can all become. And then to complicate things even further, you can have an association in terms of a sectional title context. And that is where the developer is wanting to change management rules that they actually can't change in terms of the prescribed management rules and in terms of the provisions of the Sectional Title Schemes Management Act. So you would normally find an association in a body corporate or sectional title concept where there is a bit of a uniqueness to the scheme. Maybe it's a mixed use development, maybe there's a hotel operation, maybe the developer wants to stay involved for a number of years or in perpetuity. You know, sometimes when it's a bit unique, then the prescribed management rules are deviated from, and instead of calling it management rules, we call it the Constitution, but not to be confused with the Homeowners Association Constitution. And it's very important that in that context, the title deed, the Section 11.3b Conveyancer Certificate, in terms of the Sectional Titles Act, actually specifically needs to say that there is an association. So instead of calling it ABC Body Corporate with an SS number, you'll call it ABC Association, still with the SS number, but instead of management rules, you'll have a constitution. The CSOS do need to review and approve the constitution, that is the management rules of this body corporate association. And we'll chat about the CSOS role with homeowners associations in a little while. And another important thing, that it's very difficult, if not impossible, to retrospectively create an association over a body corporate post fact. In other words, when there are members, when the body corporate has been established, because you would need to amend title deeds. So yeah, very complicated to do it. I have been quite fortunate to deal with it once before, but it wasn't without its challenges. So that is a different type of association, and it is what we call in practice a Regulation 6 association. Then, to complicate things even further, we do have such a thing as an association of persons. So this is a voluntary associations of persons. If you're in Cape Town, you'll know of Calvin Grove. That's like a country or a social club. They do have a constitution. They've got a board, members. They pay subscription fees. They've got rules that they need to abide by. But it's not a body corporate. It's not a homeowners association, neither under the common law nor under the Companies Act. It is simply a group of people that have come together with common interests or a common goal. And it is very possible to actually have an association of persons over property as well. And we've recently drafted a constitution for a very small development where a group of friends wish to actually enter into this development together and are wanting to manage themselves in a very informal manner, but still where there are common interest and common or shared expenses, they want to be regulated, which is all good and well, but the Constitution doesn't have any form of regulation. And unless it is specifically set out in the sales agreement or the title deed condition, a constitution in this format cannot be actually enforced. Then, just to take us back to NPCs and common law homeowners associations, you do also have to have a clause in your sales agreement relating to membership. You do have to have a title deed condition relating to membership, relating to getting the written consent of the association upon the sale of the property, getting the purchaser to be bound as a member and all those fun things. You can't only have it in the Constitution, you can't only have it in the sales agreement, and you can't only have it in the title deed. It's a whole flurry of documents. So again, when you're consulting or when you're asking a question, so important to ensure that you look at everything holistically to make sure that everything has been set up properly. All right, Karine, we can move on to the next slide. All right, so amendment, I touched on it briefly, both under non-profit companies and under common law homeowners associations. An amendment to the Constitution does require member consent. I've never seen a situation where no member consent is needed for an amendment unless the scheme is still within the development period. And I actually consulted with an HOA client today where only the developer needs to approve the amendments to the Constitution, because that's what the Constitution provides for. During the development period, only the developer has the rights to actually approve any amendments to the Constitution. So that could be set out in a memorandum of incorporation as well. And I did also mention that often the constitutions provide that the local authority has to give the prior written consent, but again, in our experience, the local authority first wants the members' consent. So in most cases, at least in all the cases that I've seen, both for constitutions and then of course from a Companies Act perspective in terms of non-profit companies, you have to have a special resolution of the members. A special resolution is a 75% vote, but in each homeowners association, the way of calculating that vote and the quorum can be completely different. One homeowners association could have a 10% quorum, one could have a 25% quorum, one could have a 60% quorum. It really depends on the provisions of the Constitution or the Memorandum of Incorporation. It can even provide that it must be a special resolution of all members of the association and not only a special resolution of those that are present. It can provide that it needs to be a special resolution only of those members that are entitled to vote. So there could be some clauses in the governance documents that actually takes away, disenfranchises a member from undertaking a vote. Very often that is when a member is in arrears with their contributions or in breach of the rules. They're not a member in good standing. And then one of the things that they cannot participate in is quorum calculation and voting for something as important as a special resolution for the amendment of the governance documents. From an NPC perspective, any amendment to a memorandum of incorporation, after it's been approved by a special resolution of the members, has to go to the CIPC for verification, and the HOA will receive a certificate. So that's really great. The CIPC is pretty on it, and we normally find that a homeowners association will make use of their auditor or an attorney to do the submission for them. And there's a whole lot of other documents that you need to submit to the CIPC in any event if you are a nonprofit company. For a constitution of a common law association, you need to submit the amended constitution to the relevant department. So it's within the jurisdiction that the HOA is based. It could be the city of Cape Town, it could be Milnerton, it could be Blouberg, it could be Drakensberg, wherever your HOA is based, that's the jurisdiction. And the local authority will sometimes review it and sometimes come back to you with proposed amendments, or actually required amendments. But most often we find that they don't come back to you with any form of review. Sometimes they'll send you a stamped copy, sometimes not. So you do have to be very clear in when you submit it, what you actually want in return. And then they have this checklist that I mentioned that you have to complete. And at each requirement on the checklist, you have to specify the relevant clause of the Constitution where this requirement on the checklist has been met. And as the notes say, yeah, if there's no feedback from the local authority, you accept that it has been accepted, bearing in mind, and if the wording is clear in your Constitution, as from the passing of the special resolution, those amendments are going to be valid. This is very different to bodies, corporates, conduct and management rules, because we know there that any proposed amendment has to be sent to the CSOS, and the CSOS actually first has to issue a certificate of approval, and only from the receipt of that certificate of approval, the date of that certificate of approval, are those rules actually enforceable. For HOAs, it's very, very different, but we'll chat about the CSOS route in a minute or two. The role of the developer, I mentioned that very often the Constitution or the MOI contains a clause or clauses that during the development period, the developer has the veto right or the sole right in regard to any amendments. I very often find that in governance documents, there'll actually be a provision that certain clauses of the governance document can't be changed without the prior written consent of the developer. And that could, for example, be the clause relating to the extent of the development period. A development period, for those of you that don't know, is when the developer still holds either majority voting rights or all the voting rights, maybe doesn't contribute towards the levies and has the right to actually further develop in phases the homeowners association. Sometimes it's very, very long. Sometimes it's quite a short period of time. It really is dependent on the developer. In our consulting practice, we often get the question about, it can't be fair or it can't be reasonable. It can't be in accordance with what CSOS would allow that the developer has these powers. But if the Constitution or the MOI provide for it, it is what it is. It's set in stone. So again, it's quite open-ended in this regard. Karine, we can move over to the next slide. Membership, this is a really super important clause in a constitutional memorandum of incorporation. And I find often in our consulting department that this clause can really make or break a dispute. Nicole and Rizal are currently working on a matter now where this whole concept of membership is taking quite an interesting turn. So it's very important to ensure that the membership clause deals with who the members are, what the members' obligations are, their powers, all of those fun things. A member is any person that is an owner or a co-owner of an earth in a common law association. An earth will be called a land unit within the homeowners association, and that is as what is registered at the deeds registry. If it's in the name of a company, a CC, or a trust, it would be that entity. If it's in the name of a person or persons, it will be them that are the registered owners. Often the developer is also defined as being a member. And if you are in a layered development, let's say there are multiple homeowners associations or multiple bodies corporates or even one body corporate, it's very important to see who the members are in that context. It could be the other HOA or the body corporate as a whole, or it could be the individual units or the individual urban within the HOA or the body corporates. It could even say the owners of urban are members of the association. And in that instance, all the owners of houses within HOAs would be members, but not the unit owners in a body corporate. Then the body corporate as a whole would be a member of the HOA. So again, super important if you're living or managing a layered development to understand who the members are, because if you haven't bound somebody to be a member, you can't force them to comply with the governance documents. So if you haven't bound individual unit owners in a body corporate within an HOA to be a member of the HOA, then you can stand on your head. You're not going to get them to comply with the Constitution and the Memorandum of Incorporation because they're not members of the Homeowners Association. Membership in a common law association or a NPC, or even in a Regulation 6 association in the sectional title context, is compulsory. It's not a choice. You can't opt out of it. You can't suddenly wake up one day and say, I no longer want to be a member of the HOA. It's compulsory. The moment the property is registered in your name or your entity's name, you are automatically a member of the HOA and you're automatically bound to the governance documents. It doesn't matter if you've seen it or haven't seen it, if you signed it or you haven't signed it. It doesn't matter what your sales agreement says, you are a member of the association. So very important to go and have a look at the title deed conditions, go and look at your sales agreement, go and look at the governance documentation, understand if you are or are not a member. Membership of a homeowners association cannot be transferred, and by transferring, I don't mean upon the sale and transfer of a property, but rather I can't suddenly decide that I don't want to be the member anymore. My husband must now be the member, but I remain the registered owner. The only way that he can act on my behalf is either as a proxy at a meeting, or if he holds a power of attorney, a general power of attorney or a specific power of attorney. And as I said, you can't resign from being a member of the association. I people, because very often in my consulting department, I see when owners don't like their governance documents, they're like, no, I no longer want to be part of this. I resign as a member. It doesn't work that way. Membership only terminates upon the sale of a property, and very similar to sectional title, you aren't entitled to any refund of contributions that have been validly paid during your membership. Title deed conditions, very, very important. You have to ensure that you understand what the title deed condition is in your deed of transfer, that you're bound to be a member of the HOA, that you have to get the prior written consent of the HOA upon transfer. There might be a master homeowners association. Who are you bound by? What entity? The clause in the constitution of the MOI is obviously very important, and there'll be various clauses throughout the governance documents setting out what your obligations are as a member. And then, of course, you look at your sales agreement, but you can't rely only on your sales agreement. The sales agreement itself is not strong enough to bind you, and the constitutional MOI is not strong enough to bind you. You actually do have to have a title deed condition. If anybody's interested in seeing what a copy of such a title deed condition looks like, you're more than welcome either to ask Corinne or Peter, and I can give them a copy, or you're welcome to contact us and we can show you what a copy of that looks like. If you've got any questions as to whether or not you are part of an HOA, you can also ask. And that might sound like a strange question, but I'll never forget when I started out managing properties, one of the first telephone calls I dealt with was an owner in a homeowners association that very much looked like a homeowners association, asking why they were getting a levy statement, why they were paying levies. And it came as quite a surprise to them that they had bought into a homeowners association. They got very confused between levies and rates. So it's unfortunately something that does happen, and you need to have your eyes wide open when you buy a property. Buyer beware is the terminology that we learned from first year. You are contracting yourself. You need to be very much aware and knowledgeable of what you're contracting yourself into, what you're buying into. Corinne, we can move on to the next one. Thank you. Okay, CSOS. So we are very often asked whether or not or what the extent of the CSOS involvement is in a homeowners association. So the CSOS Act, the Community Schemes Ombud Service Act, does include a homeowners association as a community scheme in terms of the jurisdiction of the CSOS, but the only applicable provisions are the fact that you need to register the homeowners association and get a registration number, that you'll contribute a levy based on the levy formula under the regulations to the CSOS Act, that you'll be bound to the regulations dealing with the duties of scheme executives and fidelity insurance, as well as the payment of levies, and that if there is a dispute, you may refer it to the Community Schemes Ombud Service. I say may because in a homeowners association, most often the Constitution or the Memorandum of Incorporation actually provides for internal dispute resolution in the form of arbitration. And And the CSOS does not automatically replace arbitration in a homeowners association. In a sectional title scheme, the concept of arbitration was in the prescribed management rules, and the prescribed management rules were repealed and replaced, and that prescribed management rule 71 dealing with arbitration no longer exists. So in a homeowners association, you may go to CSOS, or you may go to court, or you may deal with your dispute internally, but you can't go to arbitration. But as part of internal dispute resolution, you can have a facilitated attempt at resolving disputes. In a homeowners association, you very much can still go to arbitration, and you can't override an arbitration award with a CSOS order, and you can't override a CSOS order with an arbitration award. So you have to decide where you're going to go. And a question we are very often asked is, if somebody institutes CSOS proceedings, can I still go to arbitration? If somebody institutes arbitration proceedings, can I still go to CSOS? So the answer is no, you have to go to one or the other. And you can have unilateral arbitration proceedings instituted against you, and you can have unilateral CSOS proceedings instituted against you. In other words, you don't have to agree with the other side to actually have these proceedings in place. And I've dealt with quite a few instances where you have to look very closely at the timeline of events to determine whether or not the arbitration route must be followed or the CSOS route must be followed. And if you're not able to agree on who the arbitrator is in arbitration proceedings in a homeowners association, the Law Society, now the Legal Practice Council, can actually be approached to appoint an arbitrator. So they will run the process with or without you, very similar to non-appearance in court. The magistrate or the judge will still continue despite you not actually being in attendance or not participating. When it comes to registration, there's a couple of steps that need to be followed from the CSOS perspective. You need to submit your annual returns. You need to send them a copy of the Constitution or the MOI. You need to send them a list of who your trustees or directors are. If you're in a sectional title scheme, you need to send them your sectional plans. You need to send them your levy schedule that they can calculate the levies. And by now, we all know that community schemes, all community schemes, pay a quarterly CSOS levy. And it is paid monthly by an owner of an earth or a land unit or a unit, and it's currently capped at 40 Rand. And we also are aware that the CSOS has been looking at introducing a flat rate of 20 Rand per unit. So the calculation is the first 500 Rand is exempt, and then it is 2% of the remainder of the levy on a monthly basis, capped at 40 Rand. And for a unit that I own in a body corporate, I currently only pay 13 Rand 62 cents or something along those lines. So for the CSOS introducing a flat rate of 20 Rand, I would actually be paying more than what I would otherwise pay. Your levy has to be quite high to reach the 40 Rand threshold. So although some owners will benefit at a reduced flat rate of 20 Rand, in my opinion, based on just statistics, a vast majority of unit owners will actually be contributing more than what they're currently contributing based on the flat rate of 20 Rand. And there are certain exemptions. For example, if you are a layer development and you're a body corporate within the homeowners association, you won't pay a CSOS levy both on the body corporate and on the homeowners association levy. And there's certain exclusions as well. The biggest thing that I'd like to say about CSOS, though, and it's a query we get almost daily, is whether or not the CSOS has the jurisdiction to review and approve your constitution or memorandum of incorporation, including any of your supporting documents, estate rules, conduct rules, architectural guidelines, you name it. No, they do not. In terms of the Community Scheme Ombud Service Act, the CSOS have no legal authority to review and approve homeowners association governance documents. They do offer what they call quality assurance. It's voluntary. In my experience, however, literally 100% of the time, when any homeowners association submits their governance documents in whatever format to the CSOS applies the review process as they do in bodies corporates. So the practice directives relating to undesirable rules, which has very much been drafted for a body corporate, gets applied to the homeowners association, which is just plain wrong. The CSOS does not have the setup for review and approval of HOA governance documents, but more importantly, they don't have the statutory authority to review and approve HOA governance documents. What they do have the authority to do relating to governance documents is if a dispute is actually applied for under Section 38, one of the prayers of relief under Section 39 of the Community Scheme Ombud Service Act is that a clause of your governance documents can be declared to be unreasonable, unlawful, invalid, set aside. But the entire document cannot be set aside or invalidated as part of a review process, in the same way that a conduct rule or body corporate management rules can be set aside, as well as the Regulation 6 constitution of the body corporate. They also need to review and approve that. So please, 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 if you're listening and you're going through the process of amending your HOA governance documents, if you're going to submit it to CSOS, please, please, please be aware that it is voluntary. And if they come back to you with any amendments and they say, we're not issuing you with a certificate of approval unless you make these amendments, the certificate of approval means nothing. They don't have the authority to actually check it. It turns my hairs gray when I have to deal with the responses that I receive in this regard. So, Corinne, before I get carried away, we can move on to the next slide, or more carried away. All right, CSOS. So I mentioned that you can go the route of the CSOS for dispute resolution, but arbitration is still very much a route to follow. And of course, you need to ensure that if you are going to approach the CSOS for dispute resolution, that your prayer of relief does fall within those that are listed in terms of Section 39. So you'll see in Section 39 of the CSOS Act, instead of speaking about a body corporate or a sectional title scheme or a homeowners association, we speak about community scheme. Instead of common property, we speak about common areas. Instead of an earth or a land unit or a unit, we speak about private areas. That's just the CSOS Act's way of having generalized terminology that will cater for all community schemes. Actually, the common property and common areas one is also an interesting terminology point, that in bodies corporates, we speak about common property, but in HOAs, we speak about common areas. Also very important to decipher the two or determine the two when you are a body corporate within an HOA, because then you'll have common property of the body corporate, but then you'll have common areas of the homeowners association. So it just gets more and more complicated. The HOAs I've mentioned are subject to the regulations and practice directives issued by the CSOS, except the practice directives related to undesirable rules, because those are specifically for rules under the Sectional Title Schemes Management Act. Another question we get often is whether or not the Sectional Title Schemes Management Act applies to homeowners associations. No, it does not. And one of the provisions of the Sectional Title Schemes Management Act that very often gets pulled into homeowners associations, or two things actually, is the proxy limitation of 2. It doesn't apply to HOAs unless your constitutional MOI actually does restrict proxies. And interestingly, that's one of the non-alterable provisions of the MOI under the Companies Act. Or if lost my train of thought now. So it is the proxy issue and then the reserve fund. So very often homeowners association have stolen that concept of the Sectional Title Schemes Management Act to actually make provision for a reserve fund or capital improvement fund, and even a maintenance, repair and replacement plan. And I really don't think that's a bad idea. It's always good to save. The quality assurance thing I've spoken about, as well as the dispute resolution. So we can move on to the next slide. I was a little bit too quick on the previous slide to talk about that. Dispute resolution, I want to chat about it a little bit more. Very, very important, both in bodies, corporates and homeowners associations, to first exhaust your internal remedies. The CSOS actually requires it, and that will be through the process of an internal dispute resolution process, and your governance documents, your constitution or your MOI, or even your rules will actually set that out. It might be a warning system, a disciplinary committee meeting, a meeting with the board, various correspondences. You know, that is the internal process, or even approaching your fellow members, calling a meeting, going to an SGM or going to a general meeting. And of course, you can also go the route of getting an independent person to mediate or facilitate mediation through an internal dispute resolution process. We're very big on internal dispute resolution. We really do try before advising any party to go the route of arbitration or CSOS or court, because once you've started that process, it's very difficult to get out of it. And at CSOS and through arbitration, you can withdraw From a CSOS perspective, the applicant can withdraw. From an arbitration perspective, both parties have to agree to withdraw. So that's something to keep in mind as well. So again, go the internal dispute resolution route first before you consider arbitration or the CSOS. We've spoken about when you can go arbitration, when you can go CSOS, so don't forget that you can still follow the arbitration proceedings and don't have to go to CSOS. We have often in the beginning found that most people wanted to go the CSOS route because it was seen to be a quicker and cheaper process than arbitration. But I have dealt with CSOS applications and arbitration proceedings, and I can say that many CSOS applications have turned out to be far more time consuming and expensive than arbitration. So it's most certainly something to really consider before you take either route. Corinne, we can move on. So some of the clauses that I always make sure is in a memorandum of incorporation or constitution, some of the ones that jump out at me are the ones that are listed. So the objects of the association are very often it's a very important clause to understand what exactly the homeowners association is set up for, what exactly the powers of the directors and the members are, and what exactly the goals or the aims of the association is. So it could be for harmonious living, it could be for the safety and security of its members, it could be for the promotion of the interests of its members, it could be to promote communal interests. The wording of the objects clause is very important and very often overlooked. The powers of the association is important, and it's sometimes the powers of the members of the association and sometimes the powers of the trustees or directors of the association, because later on under the clause trustees or directors, you'll actually see that it speaks about exercising the objects and powers of the association. So that way it will tell you whether or not the powers need to be exercised by the trustees or the directors or the members. Member approval, a big one. Very often we find in a homeowners association that the things that we would automatically consider to require member approval is taken away from the members. We've spoken about the supporting documents very often not needing member consent. And I've, again, dealt with homeowners associations where sometimes things like the budget and the levy and sometimes even the appointment of directors and trustees don't need member approval, but it all depends on the wording of the governance documents. Notice period and proxies we dealt with. So notice periods can be very different. How meetings can be held and called can be very different. Records of an association. As a member in a homeowners association, you don't have unfettered access to the records of the association. Very different to how it is in a body corporate. So other than the whole argument of poppy when it comes to personal information, you actually might not be entitled to information in terms of the memorandum of incorporation or the constitution, and the CSOS can't override that if it's in the governance documents. The nomination process for board members or directors or trustees are sometimes very different. They can have restrictions as to who directors or trustees can be, rotation periods, retirement periods, when they can stand, when they can't stand, how the process of nominations have to be dealt with, who can nominate. I've seen very complex ones where you're almost like applying for the position. You need at least 2 people nominating you. You need a third person and all sorts of weird and wonderful things. Levies. Most often in a homeowners association, a levy is equal. However, that's not the be all and end all. You can have various different ways of recovering levies. It could be on a PQ, it could be on a size of the property, it could be based on the use of common property, it could be based on the different types of entities within a master homeowners association, but most often it is an equal levy, irrespective of the size of the property and irrespective of your use of common property. Resolutions, you get different types of resolutions. For example, in a homeowners association, you don't get a unanimous resolution like you do in a sectional title scheme. You get trustee or director resolutions or board resolutions, ordinary resolutions, and special resolutions. And most often, the only time special resolution is required is for the amendment of the constitution or the memorandum of incorporation, whereas in body corporates, it's very different. The concept of member in good standing or not in good standing I touched on. So you could be classified as being a member not in good standing if you don't pay your levies, even a cent outstanding if you have breached rules, if you're in dispute with your homeowners association. And very often the fact that you're a member in not in good standing could be as severe as not having services provided to you, like landscaping or refuse removal, not being allowed to attend, let alone participate, vote, and count towards the quorum at a meeting, and sometimes even having your access control revoked, and then having to actually sign in to the scheme as though you were a visitor. So that would not be spoliation, which is not allowed in sectional title schemes. That would be authorized in terms of your constitutional memorandum of incorporation. So yeah, pay your levies when you live in a homeowners association. And I generally find that levies in a homeowners association, obviously depending on the size, is a lot lower than in bodies corporates. I used to manage an HOA where there were thousands of urban and the levy was as low as 200 Rand. In my security enclave, that's a different form of a homeowners association. It's a non-gated estate. Security is important, and the bulk of our levies go towards security in the form of like panic alarms and monitoring. But we have public roads, public verges, and we're not gated. Our levies are a whopping 375 Rand a month. So we don't have common areas. We only have municipal parks and things like that. But we do have a managing agent that sends out our levy statements and coordinate meetings. And then, of course, the bulk of our levies go towards security. And we've got a dedicated security company with multiple trips around the estate. And if there's an emergency, we press the button and they're out super quick. I had an instance at home where I required the services of the police, and I phoned 10111 and nobody picked up the phone. And then I phoned the private security company and they were here like 3 minutes later. So very, very good to have that in a homeowners association. Then we have winding up or dissolution. I've never dealt with it myself, but it is possible for a homeowners association to come to an end, and then the proceeds of the homeowners association, in other words, the funds of the homeowners association, actually have to be transferred to a similar association and not to the members. Nicole Null and I were speaking about it today with a client. Corinne, you can move to the next slide. Supporting documents. I see we're running out of time, so I'll go through this one quickly. I mentioned in the beginning, very, very important to ensure that all the supporting documents are comprehensively set out in the main governance document, the MOI or the Constitution. It forms part of those documents, and you have to see who has the power to amend them. So sometimes the board, sometimes the trustees. Who has the power to enforce it? Sometimes the directors or trustees, sometimes the estate manager, sometimes the managing agent. And then how these documents can be amended. Special resolution for the MOI or the Constitution, but very often a director or a trustee resolution for a supporting document. So important to understand those. Corinne, you can move on. I think we're coming to the end, if not at the end. There we go. That is some of the mysteries.
Thank you very much, Linda. That was incredibly interesting and enlightening. Corinne, could we move over to Q&A, please? You can keep the contact details up on the screen, but I'm certain there are a few questions coming out of the chat that Linda can answer for us.
Yes, please. I have one that I said I'll pose to Zelinda. So Zelinda, this HOA has a constitution, but the constitution doesn't say anything about what a special resolution is. So they only have 7 members. So if you calculate 75%, it's 5.25. So the first question is, does it round to 5 or does it round off to 6? And then the second question is, will it be only those members present by proxy that will be calculated in the 75%, or must it be all members, because the Constitution is not saying anything about it?
Such a bad situation to be in when the Constitution doesn't say anything. And I've even found constitutions that don't even have an amendment clause. And if it doesn't have an amendment clause, then you need the written consent of all owners. So to play it safe, say 75% of all owners, if it's going to be done not at a meeting, or 75% of the quorum, provided, of course, that you do have a clause relating to a quorum. And I would rather go upwards. I wouldn't round downwards. But that is in terms of the common law. And of course, that is a common law homeowners association in terms of the Constitution. You can take some directive from the Sectional Title Schemes Management Act and the Companies Act. And there it is very clear as to how a special resolution is passed. So I would say in that specific situation, if you're having it at a meeting and the meeting is quorate, it would be 75% of those members. If it doesn't say anything about entitled to be a member and all that fun stuff, then you don't take that into consideration. And I would rather round up and not round down.
Corinne, any further questions from the chat? I do have a few.
Sorry, I was on mute. You can go for it.
Thank you. So Linda, I apologize for putting you on the spot, but I wrote a
No
couple of
worries.
notes.
No,
Thank
go
you.
for it.
So with CSOS and HOAs, is there a possibility of including in the management documents that an owner has to follow a specific procedure before he can go through to CSOS?
So it's a difficult one. The Constitution or the MOI can provide for that because the MOI or the Constitution does not get approved or reviewed by the CSOS, and the local authority and the CIPC is not going to pick up on something like that. In his training, Prof. Paddock specifically said that nobody can be deprived the right to go the community scheme ombud service route. But the community scheme ombud service also does say that you need to exhaust your internal remedies, and your internal remedies will be what your constitution or your MOI provides for. I have seen where the CSOS has rejected an application where the constitutional MOI does provide for arbitration, and I have also seen before arbitration is instituted, but it's spoken about, that the CSOS has said, let us deal with it through the CSOS process as opposed to arbitration. But it's so much better if the constitutional MOI is clear on that, but it can definitely force or compel internal dispute resolution. But once somebody, either one of the parties, has instituted arbitration proceedings, and to institute arbitration proceedings is as simple as saying, I want to go to arbitration, then you're done for. You have to go to arbitration. The CSOS can't override that.
Okay. And body corporates within HOAs, I've seen this a number of times. Are the members within that body corporate members of the HOA themselves, or is the body corporate a member of the HOA?
So it will definitely depend on two things: the clause relating to membership in the Constitution or the MOI, and the title deed condition. And that will be the body corporate's title deed condition in terms of Section 11.3b of the Sectional Titles Act. It is a conveyancing document, and it specifically says who the members of the association are. It will say that the owner of the earth, in other words, the body corporate, is a member, or the owners of units are members, or the owners of units and the body corporate is a member. So very important to look at that, as well as the wording of the membership clause, because it could literally say, and I've seen it more often than not, that the constitution or the memorandum clause says the owners of Irvin are members. And if you own a unit in a body corporate, you're not an owner of an earth. The body corporate is the owner of the earth, which means only the body corporate is the member.
Okay, very interesting. I mean, vote calculation there, it's a whole another conundrum.
Yeah.
Go for it, Corinne, please.
We just have a couple of questions on the Q&A. So, Zelinda, there's a question. Do you agree with Paddock's view that a developer can take the HOA to CSOS?
So I would love developer matters to be dealt with at CSOS, and they used to be dealt with at CSOS. All the matters that I've been dealing with for the last 4 or 5 years, the CSOS says they've got no jurisdiction to deal with developer matters, and I haven't seen something come out from the CSOS saying anything to the contrary. If anybody has anything, please do share it with me. I do believe, so I agree with Paddocks, that you should be able to take a developer to the CSOS, or the developer take a member or the HOA to the CSOS. But you would normally find that the dispute between the developer and the HOA, should the developer institute it, is a contractual dispute, which the CSOS doesn't have the jurisdiction on. If the HOA or a member is taking the developer to CSOS, it normally is because of a governance document issue, or an unfair provision that the developer has imposed, or even the provisions in the Constitution relating to the developer's powers. But as far as the matters that I've dealt with, the CSOS has said we don't deal with developer-related issues. Although I think a developer, as long as they are still the developer of the HOA within the development period, is a person materially affected, which the CSOS Act provides for.
Yeah, no, I do agree. Then another question is, can a written resolution that was approved and included in a AGM or SGM pack be broken up and dissected and parts, and then some of it voted on and other parts not? Or does the resolution stand as it is and must be voted on as it is, or as it was written and presented?
Yeah, good question. So in terms of the common law of meetings, you actually are entitled to propose motions and actually amend motions, but it does depend on what the Constitution says. If the Constitution is silent, you should be able to do so. In a non-profit company context, the chairperson or the directors actually do have the ability to amend a resolution. So if you were going to propose the amendments to a constitution, and all but one clause gets voted in favor, you could actually retract that clause of the Constitution, or you could change it. But my concern about material changes at a meeting is that it hasn't been part of the notice, and there's a reason that a notice is sent out, and those owners that are not in attendance or haven't got a representative at the meeting or haven't given the representative instructions would not actually be able to meaningfully partake in that vote. So yes, it can be done, but it does depend on the situation.
Thank you, Corinne.
Thank you, Zelina. That's it.
We're done there. Thank you so much. Okay. So just to finish off, please remember there is going to be a survey that is sent out right now. Please go and complete that for us. Remember to subscribe to our newsletters and other socials. Linda, thank you so much for joining us. That was absolutely fantastic. Thank you very much, Corinne. Everybody have an excellent evening, a great rest of the week, and looking forward to seeing you on the 22nd of April. Bye.
Cool. Thanks, everyone.